Hi, I'm Lucy Wojcik. I'm the Chief IP Counsel of a UK tech company called OCADO Group PLC, and you are listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzan and I are welcoming you to episode 163 of our podcast IP Fridays. Today's interview guest is Lucy Wojcik, who is the Chief Intellectual Property Counsel at OCADO Group, and we talk about cross-border patent litigation, in-house organization of IP teams, agile IP, and much more. Lucy has just been inducted into the IP Hall of Fame. But before we jump into this very interesting interview, I have some news for you. On May 22nd, the European Commission released its biannual report on the protection and enforcement of intellectual property rights in third countries. The report identifies countries where IP deficiencies cause significant economic harm to the EU interests. China remains a top priority, followed by India and Turkey. The accompanying counterfeit and piracy watch list details trends in counterfeiting and piracy, listing problematic websites and marketplaces. In May, the Trump administration dismissed Shira Perlmutter, the top US copyright official, shortly after removing Librarian of Congress Carla Hayden. This action followed the Copyright Office report, expressing concerns about using copyrighted content to train AI systems. The dismissals have sparked significant backlash from the copyright community. The UK government's proposal to amend copyright laws to benefit AI developers has faced criticism. The plan would allow tech firms to use copyrighted content unless creators opt out, a mechanism deemed impractical by industry stakeholders like Sony Music. Critics argue that such change could jeopardize investments and disrupt existing licensing negotiations. In May 2025, the US Patent and Trademark Office rejected Tesla's attempt to trademark the term Robotaxi for its vehicles, citing that the term is too generic and merely descriptive. The USPTO issued a nonfinal office action, providing Tesla with a 3-month window to respond before the application is potentially abandoned. A separate application by Tesla for trademark Robotaxi for its upcoming ride-hailing services remains under examination. Additionally, Tesla's efforts to trademark Cybercab have been delayed due to conflicts with existing trademarks containing the word cyber. On May 9, 2025, the WHO, the World Health Organization, and the Medicines Patent Pool, MPP, announced a sub-licensing deal with Nigeria's Codex Bio to locally produce rapid diagnostic testing using SD biosensor technology. The agreement, part of the WHO's Health Technology Access Program, aims to improve access to affordable diagnostics in low and middle income countries, initially targeting HIV and adaptable to other diseases and future health emergencies. Now, let's jump into the interview with Lucy Wojcik. Today's interview guest is Lucy Wojcik. If you don't know her, she's the Chief IP Counsel at OCADO Group, and she was just inducted into the IP Hall of Fame, is also member of the IP Strategy 300, and she was awarded In-House IP Leader of the Year at Managing IP. Thank you very much for being on IP Fridays.
It's a pleasure. It's nice to talk to you.
So you are leading quite a large IP team. Maybe you tell us first how you got there. When you joined OCADO, what was your role in the beginning? How did it all evolve that you are now Chief IP Counsel?
It's quite an interesting story, and I sometimes refer to it as the longest job interview in history. I was retained by OCADO as a consultant in January 2014 on a contract for 1 day a month. So I literally was employed to come in and talk to them about IP for 1 day a month. It took me about 9 days, so about 9 months, to realise that this was a great bunch of people with a huge number of ideas, an awful lot of tech, and there was a big piece of work that could be done on IP. So I gradually did more and more days a month, then days a week. And after 2.5 years of sort of gradually ramping up to, as my boss would say, 8 days a week, they decided it was a bit silly and I actually should be employed. So I was employed as the first IP professional at OCADO. They had nobody who had that formal title before, and I was employed as their head of IP. And then gradually grew the team to where we are today, which is 11 or 12 of us, depending on exactly who you count. And that growth has taken into account some large pieces of litigation we've had, a huge ramp in protection and technology development and R&D spend that we've had. So I was quite lucky, really. I always say I'm lucky because I was with the right people at the right place at the right time who saw that IP for this company was important. And so I was given an awful lot of leeway in what I did, who I employed, who I co-opted into the team, and how we organised it and ran it. And I was made Chief IP Counsel around about 2021. I think it was April 2021. When we were 6 months or so into a very large piece of litigation. And it looked a bit crazy that I was directing all of this litigation with the title head of IP. So somebody somewhere thought I ought to sound more important. So my boss gave me the new title.
Yes, let's talk about your very interesting patent portfolio. So you have tons of patents. Maybe you can also talk about how many and so on. But what I saw that you have a very diverse patent portfolio. You're patenting, autonomous vehicles, and you're patenting robot arms, and you're patenting software, and and maybe also briefly talk about the business model behind this, because you use the IP yourself, of course, but you also are a service provider to competitors of yours. They are using your system. You are basically a systems provider for competitors of yours. So maybe you can also talk about that a little bit.
Sure. Look, I mean, as far as the portfolio is concerned, the portfolio reflects the company. So much as I'd like my team to sit around and think things up and write fantastic patents, everything that you see in the portfolio has come from an idea or some potential work, or maybe a bid into a project. Where some of our engineering colleagues have actually been working on it. And yes, it is incredibly diverse. And I think sometimes that's a good thing and sometimes it's a bad thing. And so I try and walk a line where obviously we need to protect what we're actually doing. So at least 40% of the portfolio is protecting what we are actually doing, our actual robots, the arms, the software, in the States, some of the business methods. And the rest of the portfolio, some of it is slightly speculative, but it is amazing how many times we've done speculative cases that have turned out to be really important. I was in a European Patent Office opposition last week on a case we speculatively drafted in 2015, and it's now covering one of our newest and most important pieces of equipment that we're supplying to our partners. So it went from being speculative and, 2 people working on it to being a huge project in the company. So sometimes you have to take those bets. And then sometimes we've done some sort of slightly odd pieces of work that might look like they don't fit in with the portfolio, but we do have some companies that we invest in, a 3D printer company, some autonomous vehicles investments. We had a vertical farming investment. So some of the portfolio reflects that as well. So we try and keep moving and make sure that we're covering what we're doing and covering the things we might want to do and covering the things we're not sure anybody's even going to be able to do, but we'll have a go at covering them. So that's how the portfolio works. I think in terms of the business model of the company, yes, you're right. But it's also a very sensible evolution of how the company in the UK has grown up. So OCADO started as a retailer, but an online-only retailer. Some would argue a little bit ahead of its time. And what we found was, or I wasn't at the company at the time, but what they found was the equipment, the software, the technology didn't exist to do what we needed to do. And so the engineers at the time were sort of patchworking together, or sometimes the jigsaw analogy is used, of buying things off the shelf that did some of what we wanted to do, and then sort of trying to stick them together and make them work differently. And that worked for quite a while, but we knew we could be better. And that's when we just started to develop the new equipment. And that's when we increased the number of technical employees, software engineers, hardware engineers, firmware engineers, to develop a system that would work for grocery. And we then had effectively our own equipment running our own retail company. And that still happens today. So OCADO Retail Limited is the retail arm of OCADO Group, but it's now in a 50% joint venture with Marks and Spencer's. So we kind of have somewhere where a company that is using our equipment in anger, and we work very, very closely with them to roll out improvements, to change what we're doing. The new piece of equipment that I was talking about has now been put into some of their sites. And so it's almost, don't want to call it a test bed, because it isn't being tested there. It is absolutely being used. But it's a very good showcase to take to other retailers in other jurisdictions and say, hey, if you need an online offering, this is how you can do it. So we aren't really competing with ourselves, because we have our retail arm in the UK, and all of the other systems that we license are really outside of the UK. And OCADO Retail only operates in the UK. But it's great because they're a retailer and they are having all the same problems that all our partners are having, and we're helping them solve those in the same way.
Right. Okay. That's an interesting solution to the possible conflict that you are basically customers of yours are also competitors of yours, basically.
Yes,
but
they're kind of not, because of the
food
jurisdiction.
retailers are outside the UK. That you are systems provider, and
Yes.
The food retail of your own food retail business is inside the UK, where you are not systems providers to others, right?
Yes.
Okay, very cool solution to that problem. So let's talk about why you have been inducted into the Hall of Fame and why you are so famous now. So I think a large part of it, but correct me if I'm wrong, is that you did a fantastic job in coordinating patent litigation in the last years. And that was quite a challenge. Maybe you can first broadly tell us about patent litigation in OCADO, and also how you manage patent litigation in general. Like, how large is your team, who is working for you, and how do you direct outside counsel? Maybe do you use outside counsel, or do you use only in-house counsel, and how do you manage patent litigation across all these jurisdictions?
Yes. Okay. So trying to do it in order. The litigation was with a company called AutoStore, who make a very similar system to ours. In fact, we actually have several AutoStore systems within our technology landscape. they're very different. They look the same. To the outside world, you would see robots running around on tracks, picking up boxes. So they look very similar. Ours looks like that, theirs looks like that. But it's a situation where the systems are designed for different purposes. So the OCADO system is much more about grocery. So it has to be able to operate in 3 temperature zones: frozen, chill, and ambient. It has to be faster. And it is dealing with people who, if you think about your own life, if you order something from Amazon, you maybe order one thing or 2 things at a time. So a robot can pick the box, somebody can take the cable or the book or whatever, put it in an envelope, and it can go in the post. That can't work with groceries. You're having to quickly compile an order and get it shipped and delivered within all sorts of regulations about food and how it can be transported and how long you can have something frozen, not in a freezer, and things like that. So the systems have detail, which is very different. AutoStore didn't believe that, and believed that they had a patent or patent families that our system infringed. And that's fine. So they chose to sue us on the 1st of October 2020 in the UK High Court under 6 patents, in the US International Trade Commission under 5 patents, and the same 5 patents in the District Court of East Virginia. That was the start of it. That's quite a lot of cases in quite a lot of separate forums. They followed it up with some entitlement actions in the UK Patent Office. At the height of the litigation, we also had, we sued AutoStore in the District Court of New Hampshire. We had multiple PTAB cases going on in the USPTO. We had 28 concurrent EPO oppositions. We had German utility model actions where we'd sued AutoStore. We had Israeli oppositions. Just it grew, which I've never been involved in litigation before, but apparently this is quite common. It starts with a couple of cases in one corner of Europe, and all of a sudden it's everywhere. And we did, the last cases we filed were in the UPC on the first day of the court in the UPC. So there I am. The chief IP, well, at that point I was the head of IP at OCADO with my team of 10, 11 people, and this landed on our desk on the 1st of October 2020. We had been crossing swords with AutoStore before that date, but not in a big way. So we were aware of them, they were aware of us, we knew they weren't happy with us, but there'd been almost 2 years of silence. And so we never thought they'd gone away, but we didn't quite expect the size of the issue that dropped on us. Because we had been involved for the sort of 2 or 3 years preceding it, we'd got external counsel in place. I don't know what this would have looked like if we hadn't on that day literally been able to pick up the phone and say, hey, that thing that we thought wasn't going to happen has happened. But in terms of how it was organised, it was fantastic, really, because I got to take the credit and lots of other people did the work. So from my perspective, I have to be quite careful because people say, oh, Lucy, it was amazing and you did this fantastic job. But we had very close to 100 separate lawyers, patent attorneys, litigators working on this at its height. And we were working with Simon Ayrton and his team at Powell Gilbert, Garrod Beanie and his team at Sullivan and Cromwell in the US. We had James Ford and his team at Abel and Imre in the UK dealing with all the European Patent Office work. We had various people guessing rhymers in Norway. We had counsel all across Europe, the team at Valdanger under Songa. It was a massive, massive team effort. So really, everybody should get the award because it wouldn't have happened the way it did without those certainly those key people and all of their teams that work with them. And then what happens is it becomes an enormous project management exercise, because from the 1st of October 2020 through to when we settled it in mid-2023, there was always something happening. There was always about to be a case. Was it one where we were defending, or were we the plaintiff? Was it one where it was a sort of patent office action, which looks very different to a litigation action? It was a massive exercise in project management. And my job really was to sit in between all of the external counsel that were working on this and the company. So I became the sort of figurehead of it, because I was the one explaining it to the board, explaining it to the execs, pulling in expertise that we needed from so for example, it was 8 people deposed in the US cases. So it was me that was identifying them and briefing them, and then they would be briefed by the external counsel. But so it became a big exercise in project management of the world's biggest litigation problem. So it was really interesting, great fun. Shouldn't say that out loud, really. However, and there's no secret, you and I have talked about this. How do you control that so somebody doesn't say something in the European Patent Office that causes a problem in the US District Court of New Hampshire, and so on? And we were also, of course, still prosecuting a lot of these cases around the world as well. So we had to be careful that our prosecuting attorneys were not saying things in responses to exam reports that would cause us issues. The way we did it was probably the world's most expensive way of doing it. But this was an existential piece of litigation for OCADO. Nobody did anything without certain people signing it off. So particularly in the UK High Court, the European Patent Office, and the US District Courts and PTAB, if our Korean associate was responding to an examination report, that examination report went to those people to say, are we okay to say all of this? It's a slight exaggeration, because obviously we got to know what we could and couldn't say, and it got better. And that's not to say that we were trying to hide things. It's just simply the laws are different in each country. Excuse me. So because the laws are different in each country, for example, the prior art regime is different in the US to in the UK. So if you just take that as an example, we might say something in the UK that is very much directed to the UK prior art rules, but they're different to the rules in the US. So it's very easy for the opposing counsel to take what you say and run off to the District Court of New Hampshire and say, oh, but they said this over there. And even though you're then on the back foot trying to explain it. So sometimes it's better to make the judgments before you say anything. So it's a huge piece of work. In terms of the IP team at OCADO, at all times, there were 3 people working on it full time. But we're not a huge team. I don't have a disputes team. We're a team of 10, 11 patent attorneys. And the rest of the team were very much doing the day job, because we couldn't be in a position where we stopped doing all our other work just to concentrate on the litigation. So there were 3 of us from an IP legal perspective running it within the company. And the rest of the IP team were obviously aware of what was going on. We kept everybody briefed. Somebody could get run over by a bus or get ill. So you needed somebody to know what was going on all the time. So the team were aware, but they were not as much involved. And we relied very heavily on them to pick up all the work that we would normally have been doing. So in short, yes, I'm really lucky. I'm the one that's got all the things after my name. But there are absolutely a huge number of people that it took to get this from start to finish. I reckon at some points 100 to 150 people were working on the litigation, internally and externally.
Wow, it's a big group effort. And a big challenge for you to coordinate all this and your team. You say you are just a couple of people, and basically you had to have everything in check, basically, all these 150 people and all arguments coordinated and everything. So that's a huge effort.
Yes, I mean, it was. We developed a sort of interesting ways of working, which I think helped. So, for example, quite early on, probably by sort of early November, I had a PowerPoint deck that had one page on every patent that was in the proceeding. So obviously it got longer, but it meant, and I would have a little picture that came from the abstract, and I would say what the issue was with that patent, whether it was our patent or whether it was AutoStore's patent. And we kept those updated, which meant that at any time, and this happened a lot, people would just kind of stand in front of me at my desk and say, what's happened in Germany, or what's happening in Brazil, and I would be able to sort of hold up this piece of paper and say, look, it's this patent, it's this case. We had a lot of interest from our partner companies that we were working with externally, because, of course, they had a concern we wouldn't be able to fulfill our contracts with them, particularly in the US because of the International Trade Commission. If we'd have lost at the International Trade Commission and couldn't import our equipment, that would have been a real issue for us. So these sheets of paper or PowerPoint presentations were really useful to be able to give to people that very simply explained what was happening in their country or their piece of equipment. And I think that helped us doing the translating, because, look, you know, you and I are IP experts, and people listening to this call are IP experts. You know, I've got 5,000 people that I'm working with who are not IP experts, and they need to understand what's going on and what they can and can't do in a way that they can apply to their day-to-day business. And so that was what a lot of my job was about.
Yeah, let's talk about these 5,000 people that you work with that don't know about IP, because before we started this interview, you told me that they are all using agile, and they are using Scrum and sprints and these kinds of things, and the 80-20 principle and whatever. So, and I always thought this is completely incompatible with with IP, but you told me otherwise. So you're very much involved with all these concepts of sprints and Scrum and these kinds of things. Maybe can you tell us more?
Yes, I think, look, I hope it's working. It might not be working. But the way I have tried to create the IP function at OCADO is that it isn't a team of people who sit in an ivory tower and wait for people to arrive and say, I've invented something. I think that leads to a disconnect. I don't think you can add the value that we can if we behave like that. So I've always, again, I've been very lucky to have had the support of the CEO, the general counsel, the CFO, the chief operating officer, who just kind of say, look, we don't care how you do it, just go and do it. We need you to do it, go and do it, whatever it is. And so I quite early on invited myself to lots of meetings. I went to the engineering steering meeting. I went to the e-commerce software steering meeting. And as the team got bigger, I put them into those meetings. So we are very much part of the engineering software technology organization. We sit in the what's called legal and business integrity. So we sit next to the lawyers, but we spend most of our time, or my team do, in with the engineers and the engineering teams. So by definition, the IP team are involved in the scrums and the agiles and the various sprints. We have 6-week sprints sometimes on certain bits of the robot and things like that. And so they're living it with the engineers. And they are empowered from an IP perspective to make the decisions themselves. At what point does what we've just done become important enough to protect, or do I need to wait for the next 6 weeks? So depending on what team you're sitting in with, my head of the software division will decide whether or not something we should designate it a trade secret or whether we should be writing patents on it. The hardware team are doing a lot of work on what we call value down now, trying to make the prototype products, manufacture them and make them cheaper. And they are empowered to make those decisions themselves when they think they've reached the right threshold to do something. So not at every sprint, but maybe 1 week they say, okay, actually, you've got to a point where I think we should protect something now, and they do it. And it might not be the most efficient way of working from an IP perspective. Patent attorneys like to get to a point where there's a clear invention. We all know what we're talking about. We can draft a very nice claim and we can file it. I'm probably going to go out on a limb here and say we maybe are not great at that. We might file things too early and then 12 weeks later say, well, actually, we need to update that case. So sometimes we can be a little inefficient. But I think what we have achieved is that we are on the right journey with the engineering teams. And so they understand what we need to know. We're very embedded in their teams. We go to all their away days and team meetings and things. So we're very much thought of as part of the engineering team. And I think, and I hope, that's why we, maybe with some inefficiencies and imperfections, achieve a good position to be in protecting the company's IP, which is, after all, what we should be doing.
Right. So you're very customer centric for your in-house customers, basically, for the engineers that you are providing value for, or that you are providing value for everyone in the company. But the origin of the ideas comes from the engineers, and you really, think about how you can accommodate their needs into your business, basically, and not other way around.
That's right. I like my attorneys to really try and understand the commercials of the business. And I think I feel quite strongly about it. We can't add value if we're not that involved in the engineering, in the commercial aspects, in the contracting. And if we're not involved at that level, we might as well be private practice attorneys who are working at arm's length. So if we're going to the effort of having an internal team, let's add as much value as we can. And that, ironically, might not be about drafting the best patents or the most patents. It's about the team's understanding why NDAs or non-disclosure agreements are important. It's about the entire company understanding that you have to sign in and sign a sort of very light touch confidentiality agreement when you go to any of our sites. It's about the engineers who we encourage to go and give talks and presentations at conferences, knowing what they can and can't say and who they need to ask about it. And those are all things that, of course, any private practice attorney can do that work. But in terms of value for money, it would be a very expensive way of doing it. So having an in-house team, we probably spend maybe 50% of our time drafting and prosecuting, and the rest of the time, IP evangelists, we're training people, we're in these meetings, we're helping understand why you can't go and talk about this new piece of equipment, why you can't take pictures of it and put it on LinkedIn, all those kind of soft aspects of IP that we can deal with because we're there in the moment with all the right people.
That reminds me, before we recorded this, we talked about, or you talked about a concept, delivering something like delivering the best value in a given situation or something. Can you say that in your own words and maybe talk about this?
Yeah, I think it's part of a shorter version of what we've just been talking about. Right. I think sometimes when I explain this to my team, I will say we can't be treating every IP question or situation as an exam question in IP. In the commercial situation, particularly in a company like OCADO, it's very fast moving. And sometimes our job is to do the best we can with the resources we've got at any given time. And I remember going through the litigation, and it's quite an unnerving thing to have to be involved in litigation in patents that you've drafted or that you've amended the claims in. It's quite terrifying when people start discussing your work. But I very quickly realised that we always were doing the best we could at the time with the resources that we'd got. And in any commercial situation, you are never going to have all the resources that you want, all the time that you need, all the people involved, everybody listening at every meeting. It's just not going to happen. So sometimes we have to expect that the best we might achieve for a given situation might be 80%, it might be 70%. It might not be the best drafted patent in the world, but it did what it needed to do at the time, which was to enable something commercial in the company to happen while still protecting the IP to the best of our ability. So I frequently say that, and I was in a meeting this morning where I said, I don't ever want the commercials of a situation to be slowed down or stopped by an IP issue. So we are never going to say, no, you can't do that because there's an IP problem. We're going to say, can you label everything confidential? Can you do this? Can you make sure there's a non-disclosure agreement in place? Can you give us as much information as we can so we can give you the best advice we can? And that might not be perfect, but it's the commercial reality. And we have to, as in-house attorneys, be able to deal with commercial realities. So I think that's what I was kind of trying to say. Sometimes, people might in 5 years' time look at something we did and say, gosh, you could have done a better job of that, or why did you do it that way? But you always have to remember that there's a context to anything that's happening, particularly in a commercial environment.
Yes. We have talked a lot about very interesting different aspects of your IP life, but in the end, I wanted to ask you if you have what your most important advice to other in-house counsel would be, like to other people in your shoes, basically, that may just start in their career. What would be the one thing that you tell them? Think about that.
Always remember who you are writing an email to. And that's a short form way of saying it. As in-house IP attorneys, particularly the more senior you get, but in my team, that's across the board, you are dealing with and talking to on a day-to-day basis with a huge range of people. You can be talking to the CEO. You can be talking to the general counsel. You can be talking to the CFO. You can be talking to a brand new graduate engineer. You can be talking to somebody in recruitment. You can be talking to one of the lawyers. And if you are having to impart some IP information to them, you need to be very, very conscious of who is on the other side of the conversation. And I've seen, to be fair, not in my current team, but I've seen some IP attorneys write amazing emails or give amazing presentations. And the people that have received the information have not really gained what they needed to out of it. So if I'm talking to the CFO, I know what he wants to know. How much is this costing me, Lucy? What's the return on my investment, et cetera, et cetera. If I'm talking to the CEO, how is this protecting the company? What's the strategy for going forward? If I'm talking to the general counsel, how am I making sure we don't end up in litigation? So it's all about giving the information through a lens that the other person needs the information. I picked up a tactic from our engineers who use something called TLDR. Now, I'd never come across this. I thought it was absolutely brilliant. So I've got to this ripe old age until about 5 years ago, and I came across this. TLDR, too long, don't read. And I now use this a lot. I will put TLDR across the top of the email, and I will say, here are the 3 sentences of what you really need to know because you've asked me a question. And then underneath, I will give them the analysis from an IP perspective or from a commercial IP perspective. And I know that if I sent an email like that to our CEO, he will read the whole email because he's interested in that sort of thing. But I know that if I send it to my CTO, he may only just read the TLDR. But the important thing is they got the information that they needed. So in short, always think of your audience and reread that email and make sure you've not used too many IP terms, and make sure the person who asked you the question is getting an answer that they need.
And really very good advice. Thank you so much. One very last question. You also dealt with 150 or so outside counsel, and maybe they also can learn from your experience. Like, what was the one thing that you wish they would do and they didn't? So
that's a really good question. And it's actually impossible for me to answer because they were exactly the outside counsel I needed them to be at the time. So I can't honestly think of anything because they were brilliant, and we set up between us a framework that meant everybody got the information that they needed when they needed it. I think sometimes
maybe not talking about the outside counsel that you worked with closely in the litigation cases
but
that you just mentioned, but maybe things that you saw in outside counsel and you thought, well, maybe they could have done this differently, so I would be more pleased or something.
Okay, that's interesting. Right at the beginning of my time at OCADO, nobody knew who OCADO was. I was the only IP person there, and there were only 2 or 3 cases in the entire portfolio, literally 2 or 3 cases. And the outside counsel at the time were very keen on charging us for coming on a train to talk to us. And I understood it because I'd come from private practice. So I understood how private practice is billed. But my general counsel didn't. And he was, why are we paying these people to sit on a train to come and do work for us? Aren't they going to make enough money once they're doing the work for us? So I often think that bit to myself. You know, sometimes, especially with smaller companies or startups with smaller portfolios, you might need to underbill or take a little bit of a loss in order to see the big picture going forward. So always question whether it's worth that line on the invoice, because sometimes the people assessing that invoice are not of the same mind as you and are thinking about it very differently. And always be honest. You know, I think that's another important thing for outside counsel. You know, I'd rather they'd said, look, we can't do this work. You're too small a bet for us, and we're too busy with big clients at the moment. That might come quite difficult to say, but it would be better to have received that information from certain people. But to be fair, I've been extremely lucky with all the external counsel I've dealt with, either in litigation or in the prosecution. So I think those are they feel like quite big things to have said, but from my perspective, they were quite small niggles at the time.
Wow, that's a big compliment to all the outside counsel that you worked with in the last years. So great. Yeah, thank you very much for letting me picking your brain about all the different aspects of your IP life, coordinating the litigation, how you organize your team, how you deal with Scrum, and so on. So there were so many different, really interesting aspects that would be very helpful for the listeners of this podcast, I'm sure. So I'm very grateful for your time. Thank you very much for being on IP Fridays.
It's a pleasure. Thank you for inviting me.
Thank you.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.